These minimum service requirements affect how real estate brokers and their agents may do business in Utah. Let's review a few examples. Assume a real estate brokerage wants to offer multiple listing service, MLS, advertising services only. They want to charge sellers a flat fee to place their properties on the MLS. Is this an option in Utah? It is an option, but not with an exclusive brokerage agreement. If the broker wants to use an exclusive brokerage agreement, the listing broker must agree to perform all the services we reviewed previously. This means, in addition to listing the property on the MLS for the seller, the broker must accept offers, deliver offers to the seller, assist the seller in preparing counteroffers, and answer any questions a client may have regarding any offers. The broker must do this until the property closes or the agreement expires. What if a seller agrees to limited services in the actual exclusive broker agreement? Assume the broker has their attorney draft an exclusive brokerage agreement which specifically states the only thing the broker will do for the seller is place the property on the MLS. Would that make a difference? An exclusive brokerage agreement, which limits the services offered, would be in violation of Utah law, and the broker would be subject to discipline by the Division of Real Estate if attempt to enter into such an agreement. If a real estate broker wishes to enter into an agreement wherein their only obligation is to list the property on the MLS for the seller, the agreement must not be an exclusive agreement. Under such an agreement, the broker would not be afforded the protections offered under the exclusive agreement we discussed earlier. Assume a buyer wants to hire a real estate broker to handle the contract portion of the transaction. The buyer does not want the broker to help them find a home, but only wants assistance in preparing the offer. Would this be allowed under Utah law? Again, if the broker wants an exclusive agreement with the buyer, they must meet the minimum service requirements set forth in the statutes. Just writing an offer does not meet the requirements of the statute. The broker must also present the offer, assist in communicating with the seller, and answer any questions the buyer may have regarding the transaction. What if the broker offered to write the offer, present the offer, assist the buyer through the negotiations, and answer any questions the buyer may have regarding the transaction? However, the broker refuses to show the buyer any properties. Would the law allow the broker and buyer to enter into an exclusive brokerage agreement under these terms? The statute does not require the broker to show the buyer any homes. The requirements are as we have discussed them. According to the statute, the broker and the buyer could agree in an exclusive brokerage agreement that the broker will not show any properties and be in compliance with the law. If a broker and their client want to limit the scope of representation, they may do so under any other type of agreement allowed by law other than an exclusive brokerage agreement. Utah administrative rules also define the duties owed by an agent to a principal in a transaction. Remember, both the principal broker and the agent associate broker act as an agent with regard to agency and fiduciary duties. The rules break down the duties depending on who the agent is representing. The duties of a limited agent are a bit different. A limited agent still owes the following duties, subject to the exceptions we will discuss: obedience, reasonable care and diligence, holding safe all money or properties entrusted to the agent, any additional duties created by agreement. A broker or agent may not act as a limited agent if they are also a principal in the transaction. For example, assume a real estate licensee is selling their own home. A potential buyer asks the owner agent to represent the buyer in a transaction where the buyer will purchase the agent's own home.